Without objection.
Thank you, Mr. Speaker. Mr. Speaker, I am pleased today to bring this rule forward on behalf of the Rules Committee. The rule provides for consideration of H.R. 3003, the No Sanctuary for Criminals Act. The rule provides for 1 hour of debate, equally divided between the chairman and ranking member of the Judiciary Committee. The rule also provides for a motion to recommit. Today, the Rules Committee had the opportunity to hear from my fellow Judiciary members, Mr. Johnson of Louisiana and Ms. Lofgren from California. H.R. 3003 received consideration by the Judiciary Committee as part of a larger bill, the Michael Davis Jr. and Danny Oliver in Honor of State and Local Law Enforcement Act. That legislation was marked up and ordered reported by the Judiciary Committee on May 24th. As a co-sponsor and strong advocate of the Davis-Oliver Act, I support the passage of that legislation before the full House. Today, we have the opportunity to move an important piece of that bill forward and to strengthen our policies against jurisdictions that flout America's laws. Mr. Speaker, the No Sanctuary for Criminals Act is just simply common sense. John Adams said that we are a government of laws, not of men. As we approach the 4th of July week, we recognize that America's foundation is that of the rule of law. Yet too often we have seen local jurisdictions ignore federal immigration law and declare themselves sanctuary cities, as though their actions have no consequences for their law-abiding neighbors. The reality, however, is that the localities that refuse to enforce federal immigration law undermine public safety and break the democratic contract. Mr. Speaker, the sanctuary cities do not act in a vacuum. They endanger lives as well as setting dangerous precedent. To many people, it would seem obvious that local and state law enforcement should comply with federal immigration law and cooperate with its fair enforcement by communicating openly with federal officials. It would also seem clear that jurisdictions that ignore these laws should forfeit the federal funds set aside to support compliance with those same laws. Despite this, sanctuary cities oppose federal immigration officials routinely. These men and women find themselves handicapped by local officials implementing obstructionist policies. In light of this, Mr. Speaker, I believe we need to better protect our communities by ensuring our laws are followed. H.R. 3003 takes steps to do that. I would like to thank Chairman Goodlatte, Congressman King, and Congressman Biggs for their work on the No Sanctuary for Criminals Act. These members, their colleagues of mine on the Judiciary Committee, recognize the need to respond to the continuing problem of sanctuary cities with resolve, with confidence that federal immigration laws safeguard every American community and apply equally to every American community. The underlying bill provided for by this rule also includes legislation offered by Mr. King, the Sarah and Grants Law. Sarah and Grants Law is named after two individuals, Sarah Root and Grant Ronnebeck, who were tragically killed by unlawful immigrants. The unlawful immigrants were released and remain at large, and the Root and Ronnebeck families were left to grieve unspeakable losses while the lawlessness continues. It is past time for us to take action to combat dangerous sanctuary policies. We're a nation of laws, and we need to act like it. While there is no uniform definition of sanctuary cities and no comprehensive or official list of these jurisdictions, we have regrettably become all too familiar with them. So-called sanctuary cities are those jurisdictions that obstruct immigration enforcement through noncompliance with the detainers. They construct unreasonable hurdles to compliance and create barriers to communication between immigration and custom enforcement and local personnel. We understand that ICE has a job to do and that its officers took oaths to uphold those duties. Opponents will claim that this bill is unnecessary because ICE has the jurisdiction it needs. The truth is, sanctuary policies make the ICE agent's job more difficult, more dangerous, and endangers communities. While the previous administration frequently flouted immigration laws and for far too long took a rain check on holding sanctuary cities accountable, even former Department of Homeland Security Secretary Jay Johnson agreed that sanctuary cities shouldn't simply be allowed to decline to cooperate with federal authorities. In fact, he said in 2015 that it is not acceptable to have no policy of cooperation with immigration enforcement. You see, Mr. Speaker, faithfulness to the law isn't like being offered a cup of coffee. You can't look at the federal statutes and say, you know, no thanks, but I appreciate you offering. H.R. 3003 confirms that this option is not on the table. While I agree with former Secretary Johnson that we must have a policy of cooperation, the policies of former administration too frequently didn't indicate a commitment to that goal. In fact, state and local jurisdictions ignored more than 12,000 federal detainer requests in 2014. Now is the time for action. Thankfully, President Trump issued an executive order directing the Department of Justice, the Department of Homeland Security, and ICE to ensure that sanctuary jurisdictions are ineligible for federal grants and are subject to enforcement actions. The President also charged these agencies with reporting on jurisdictions that have refused to comply with detainers to hold criminal aliens. The first week of this report was issued. It showed 206 known instances in which local personnel declined ICE detainers and released criminal aliens. These aliens re-entered the communities after they had committed crimes such as assault, aggravated assault or battery, driving under the influence, or domestic violence abuses. The reports indicate that we have work to do, but it helps us by identifying jurisdictions where personnel are thwarting federal law. It throws into relief the glaring problem of sanctuary cities and provides information law enforcement and lawmakers can use as we assess the problem and develop meaningful solutions. Mr. Speaker, I was in the Georgia State House when we took action there to address the issue of sanctuary cities. In 2009, we in Georgia outlawed sanctuary cities in our state. Last year, the legislature went further by requiring local governments to certify their cooperation with immigration officials in order to receive state funds. Today, we have a chance to take a step in a positive direction on the federal level. The No Sanctuary for Criminals Act prohibits states and localities from implementing policies that restrict law from cooperating with immigration law and officials. It gives teeth to that restriction by tying eligibility for certain Department of Justice and Homeland Security grants to state and local compliance with existing immigration law. The bill requires that there will be probable cause before ICE can issue a detainer and focuses on grant programs reasonably related to the scope of the bill. Importantly, this bill also calls for aliens to be detained if the alien is engaged in a crime that caused the death or serious injury to another person. Had this provision been in law at the time, it could have helped prevent what happened in the heartbreaking death of Sarah Root, where an alien who caused her death was freed on bond and remains at large. The No Sanctuary for Criminals Act also takes the common sense step of allowing DHS to withhold aliens rather than transferring them to sanctuary jurisdictions, even if the jurisdiction has a warrant. It simply doesn't make sense for DHS to transfer aliens who are removable under the law to jurisdictions that are looking for opportunities to let them go.